Representing the appellee, Kara Henry, is attorney Michael Piekny.
Okay, thank you very much. Good morning, counsel. We'll hear from counsel for the appellant first, of course. Please start by introducing yourself, identify your client, and then proceed.
Good morning, Your Honor. May it please this honorable court, my name is Melvin Fink, and I represent Jason Carrara, the appellant in this matter.
Thank you. Please go ahead.
Thank you, Your Honor. And as I said, may it please this honorable court. 15 VSA, section 752, instructs that the court may order maintenance, either rehabilitative or long-term in nature. And that particular section also provides guidelines, therefore, to determine the amount, duration, etc. The court in this case, the trial court, determined that the award would likely be short-term in nature. But there is no term specified. Query, what then is the duration? Is it 1 year? Could it be 5 years? Or is it something somewhere in between the two? Rehabilitative maintenance need be time limited. It is not so limited from the award in this case. 2, the court makes reference to the appellee later seeking a modification. What then is the term that appellee would seek to modify? The property award is also problematic. 2143 Rockingham Road was acquired by the appellant well before the marriage and was used exclusively as an integral part of the appellant's trucking business. Plaintiff requested the court assign the property to him to enable him to attempt to rebuild his business when he was released from incarceration. And Ms. Henry specifically disclaimed any interest in and to that property. Then, without explanation, the court awarded 2143 Rockingham Road to Ms. Henry. These are the reasons that the appellant seeks remand for these two issues. Thank you. And I will reserve any further time for rebuttal.
Understood. Thank you very much. We'll hear now from counsel for the appellee. Please start by introducing yourself, identifying your client, and then proceed.
Good morning, Your Honors, and may it also please the court. My name is Michael Piekny, attorney for plaintiff appellee Kara Henry.
Thank you.
Good morning, Your Honors. We're asking the court today to uphold the trial court's order, specifically with respect to the court's award of property division and the maintenance award. I think the first point to establish is we have from the trial court ample findings covering all issues of its award. That's both PRR and PCC and maintenance and property. We have over 20 pages of detailed findings giving sufficient basis for all of the court's awards today. With respect to the property award, the trial court enumerated all 12 factors laid out in 751, made findings and conclusions for each 751 factor, and ultimately awarded the 2143 Rockingham Road parcel to Ms. Henry. Both sides in their briefs actually seem to agree that under 751, this is marital property. That seems to be uncontested. It's also important to point out that this property division heavily favors the appellant. And as the appellant points out, that this is because he had brought the largest share of the property to the marriage, he should be entitled to the largest share of the property division, which in fact he is by an overwhelming margin. And so we have, the appellant talks about this was a supposedly equal property award, and it is not supposedly equal. He is heavily favored, but we do point out that this is an equitable award. So we think that trial court's equitable function is clear under 751, that it sits as a statutorily independent role, as this court has recognized.
So,
Outside it,
Mr. Panicky, you agree that this would be rehabilitative or compensatory maintenance, not it's not permanent maintenance.
correct. The trial court is clear of that, Your Honor. I think the trial court says this is maintenance likely to be short-term under the guidelines. And I would point out that that is a regime of maintenance that this court has completely sanctioned. Ironically, in Henry versus Henry at first, and then later it comes to Arbuckle versus Ciccatelli. These are cases not cited in our brief, but we rely on them here today, where a temporary, if I could read from the court's opinion in Arbuckle, quote, a court may award maintenance in a nominal amount to preserve the court's ability to modify the award later in the event of a real, substantial, and unanticipated change in circumstances. And that's what the trial court is signaling that it's doing here. It sets that temporary placeholder and sets when the conditions ripen, if they do, upon Mr. Carrara's release from incarceration, Ms. Henry would have that prerogative to modify.
Thank you.
And so I would add that I don't think appellant overcomes the issues in 751 as to whether or not this is marital property subject to the court's division. It clearly is. Mr. Henry gets the majority of the property award. Ms. Henry gets the minority. This is therefore a very equitable award, and the court leaves ample findings and explanations of why it did what it did with respect to awarding this property to Ms. Henry. And we get to the maintenance again. We understand that Mr. Carrara's incarceration makes it impractical for him to be assessed the full freight of maintenance that he might otherwise have to pay Ms. Henry. And so again, the court set that nominal placeholder, listed all the factors in 752, including the guidelines, made clear reference to the guidelines that those would be controlling based on the length of the marriage in terms of any final duration of the award. And under Arbuckle, under Henry, that is a completely proper regime for maintenance. That structure has been sanctioned by this court, that we have a temporary placeholder, we have guidelines serving as the backstop, and then that prerogative to modify as the sort of function to make sure the award gets its modification if the conditions are ripe for it. And so we are asking this court to uphold the trial court's decision in its entirety with respect to maintenance and with respect to the property award. Thank you.
Okay, thank you very much. We'll turn back to the appellant. How much time does the appellant have, please?
Appellant has 2 minutes and 8 seconds remaining.
Counsel?
Thank you, Your Honor. And once again, may it please this court. I want to make it very clear that Mr. Carrara in this appeal is not challenging or making an issue about the equitable value of the award made by the trial court. The trial court determined the value of the Rockingham Road property and awarded it to the appellee. But it was the award of the property, not its value, that is being questioned here. The court could very well have awarded the appellee the amount of the fair market value of that property as was determined by the court, and not the property, for the reason that the appellee disclaimed any interest in having that property. And the appellant specifically asked to be awarded that property so he could try to continue doing business once he was released. I also want to suggest that with regard to the maintenance, there is no backstop. The guidelines, while was indicated that they probably—
You have 1 minute, counsel. 1 minute.
Thank you, Your Honor. While it was indicated that the guidelines, the guideline would be helpful, the guideline wasn't used to be a determination. So there is no backstop of 1 year, 3 years, 4 years, or 5 years. We don't know what that is. Thank you.
Okay, thank you. Please call a conclusion of the hearing.
The next hearing for the court is